One thing that comes up that kind of rubs me the wrong way, and I always tell people this, is that if you're thinking about filing bankruptcy and you're involved in a relationship where you're thinking about getting married, I want to know about that up front. And the reason I want to know about it is because there's several rulings in the bankruptcy court which kind of are not the most favorable to marriage, you might say. And here's a perfect example. Let's say my wife and I are about to get married. Well, my fiance and I are about to get married. I come in and I have a lot of credit card debt, but no job. She comes in, has a great income, but no debt. Well, if we get married first and file bankruptcy, there's what's called an economic unit theory, which the court has now employed, and they may use some of my wife's income to pay my pre-marital credit card debt. That kind of rubs me the wrong way because it can have adverse consequences to a marriage, obviously. Why should she be required to pay some of my debt? Alternatively, and that case came out of a case where it was a long-term marriage. The majority of the credit card debt was in the wife's name, but the husband had all the income. And there I think the court got to the right unit or thing, but the idea of the economic unit theory kind of scares me going forward, because it could be expanded, and there's no contraction of it. So that's the problem I have with it. So that's something we always got to worry about. So again, if you're thinking about getting married, there's no way that the wife outside of the bankruptcy, or in my situation, there's no way my fiance could have paid $1 of my debt because she never signed for it. But when I get married, even though she never signed for that debt and the creditors can't sue her outside of bankruptcy court, now we're saying in the bankruptcy court, we may want to tap into her funds to use it to pay this, because I'm getting a great deal. My position there would be file the bankruptcy before you get married, file a Chapter 7 or whatever it is, get it done, over with, and then get married, no strings attached. So, I guess my point is the bankruptcy could be used as a sword and a shield for the issue of marriage. It could be detrimental to get married when outside the bankruptcy court, nobody could have touched that. So it doesn't make sense to me. It just doesn't seem fair. But again, there's all different types of factual scenarios that could arise there. So while I was talking about the court making the right decision in that one case, that same logic applied to my fact scenario may not be the best decision. It may not come out to the best decision for me. And I wouldn't want to put my client in that situation where they would have to litigate that issue, because that would be something to be ugly.